Good evening, ladies and gentlemen. That's my pleasure to be here, and it's the first time to be in Liberland, and I really appreciate your warm welcome, and I'm really glad to be helpful in some cases which already happened, and the previous speakers already talked a lot about it, and we already have brief talks with Minister of Justice, with Mr. President, with Minister for Foreign Affairs, with some officials of Liberland, and we'll try to do our best in order to achieve a justice, because even at least yet the Liberland is not considered by some by the states as a self-proclaimed entity, but still we all governed by the several international conventions, and the first one is most important is the European Convention on Human Rights. Just a couple of words about the speaker. My name is ALEXANDER SURZHIN. I had been working 4 years at the European Court of Human Rights, dealing with the cases against Russian Federation and the Ukraine. Because being binational, I'm attached with ongoing conflict and with the consequences. Currently, I'm also acting as an international consultant for Council of Europe projects, and we already realized some projects I was in charge for some projects for Georgia, Armenia, and it was Belarus, even it was not ever a member state of the Council of Europe and a member of a convention, but still it was a collaboration between the Council and the Belarusian authorities. Disclaimer: the presentation given the general information about what's this Council of Europe system, the legal framework given by the court, European Court of Human Rights, and within the framework of the Council of Europe there are several conventions. It's not only European Convention on Human Rights, to which Croatia and Serbia are parties, and even we consider this territory as the euro as a part of Serbia, or as Croatian authorities claim, and trying to execute their jurisdiction. We already discussed it with the Minister for Foreign Affairs that such a extraterritorial execution of jurisdiction is completely unlawful from the standpoint of international law. The European Court of Human Rights, based in Strasbourg, as you may know, and it governs under the European Convention on Human Rights, which actually my presentation called in a very simple way, because initially it was focused for the professional auditoria, and my colleagues asked me to make it like easier for understanding for general public. So the convention actually covers all, but it's of universal character. So there are at the moment 46 member countries, and without considering the fact, are you a national of the member state or not, or you binational, or you apatride, a person without nationality, you are protected by the terms of the convention. And actually it's not only the questions of criminal law and criminal procedure, it's also civil law, it's also commercial law, it's also interference in the property rights, it's also family disputes, it's also inheritance. So it's quite wide spectrum. And it's important to highlight as well, because quite often the lawyers, not only general public, but the lawyers, they claiming that Strasbourg Court and the convention, it's something far away, but it's wrong, because actually from a moment of interference into the individual or legal entities' right, the convention start to be applicable. So it means that as soon as possible, you have to switch the full ample of rights protected by the convention, and it has to be well substantiated on the domestic level before the domestic authorities. And unfortunately, but it's like it's a fact what we have. But quite often, domestic lawyers they dealing from one side. They could be like sort of influenced by the authorities. They could have like sort of direct or indirect relations, and some even if we talk about rule of law states and about unbiased justice, but it's unfortunately it's exists, and it's also not only in like sort of Eastern European countries, but it's also in Western Europe. And quite often, in order to strengthen the position of the applicant, you have to switch the full spectrum of rights under the convention and to highlight it. And for instance, if it's like the criminal proceedings and the events actually happened in Liberland, then the Croatian police violating not only the domestic law, because as we discussed, the practical execution of rights and of the practical execution of by the state authorities of their their responsibility there. So it has to be aligned with the guarantees of the convention. And but one of the main point which is mandatory under the convention, before go to a Strasbourg court, you have to exhaust the domestic remedies. So what we are talking here, that you have to raise all the issues under the convention on the domestic level, and quite often it's hindering the lawyers to proceed with proceedings before a Strasbourg court and to raise the complaints under the convention. But like in case of Liberland, for instance, we already discussed that the numerous cases, and actually they happened nearly every day, like interference into the rights of individuals here in Liberland. And like colleagues said, there is no positive prospect for no positive outcome for dealing with those cases on domestic level. However, even if it's like this, but you have to substantiate it properly. You have to explain before the court that exhausting the domestic remedies is pointless, because it's even it's formally you have your rights, but you're not able to use it properly, to execute it. So, but it has to be properly substantiated. Well, there are several. It's some legal terminology. I'm sorry for some references with the case law, etc., etc. But it's interesting points that first it has to be under the territorial jurisdiction of member state. Then, if the complaint raised in Strasbourg court, the applicant has to prove that the state respondent has effective control. So even like, for instance, we consider that Croatia is the Liberland never be a part of Croatian territory. However, they executed their rights and they executed their jurisdiction out of scope of their jurisdiction, outside of their territory. So, and there are already several cases of Transnistria, for instance, or Karabakh, or recent cases of Donbass, of Crimea, of North Cyprus, of Kosovo, where the court finds violation of applicants' rights, even if it was not within a precise jurisdiction of a respondent state. So there are also several instruments under the convention, which also may be widely known to general public, so-called procedure under Rule 39, which actually could stop the extradition procedures, for instance. Like, as Vasilisa, for instance, know, I had been a part of legal team of such a maybe well-known here person as John McAfee. And unfortunately, given the fact that we tried with a Spanish lawyer to substantiate properly all his rights and inability for the Spanish authorities to extradite him to the US. Yes, if he would be extradited there, it would be a clear violation of his rights under the convention, and Spain bear responsibility for this. But unfortunately, you know how it was ended. But this is quite effective measure which we have under the convention. It's also concerning the Liberland, because is a conception of continuous interference into the applicant's rights under the convention. Yes, this interference, like here in Liberland, it happened long time ago, and it's of continued nature. So it's interference in the property rights, in the right of liberty, and it's also right to freedom of expression, etc., etc. It's also constant pressure from the Croatian authorities to the Liberland authorities and individuals, as far as I understand. Well, there are some examples of execution of such practical application of such continuing interference, which could be in continual violation of right to peaceful enjoyment of possessions, of continued non-enforcement of domestic court rulings. And there are some basic information about what about the convention is, and which articles, what fields of rights covers by the convention, and what we could complain about. So it's, as you may see, it's some grave violations, as torture, ill treatment, illegal detention, procedural violation, because quite often, as you may know, execution authorities, they quite often they miss time limits. They don't, for instance, if it's a restriction measure, even if it's allowed by court, but if it's like sort of copy paste, you know, or if it's the extension of restriction measure, and if it's copy paste, if it's not well substantiated, it's already the case law of ECHR, which says it's violation of Article 5, for instance. So it could be also parental rights, it could be right to respect private and family life, home correspondence. So like, for instance, if someone listening to your phone without your knowledge, or someone checking your correspondence without your knowledge, this is also a violation of Article 8, for instance, and there is already well-established case law about this. And even like the evidences collected by the prosecution by such a way, actually it lacks the whole procedure of the fair trial. It doesn't correspond to the fair trial standards. And it's, for instance, it's a case law like a case Bykov against Russia, where is evidence is collected by special services, by unlawful interference into correspondency, and even they even it was well substantiated by the prosecution, but the Strasbourg court found it unlawful, and actually it's ruined all the case. So quite effective. That's again some general information about how what precise information has to be like in order to raise complaint before the Strasbourg court. And again, I have to highlight the main goal of a lawyer specialized in ECHR law or international law is not to go to the Strasbourg court, but instead to raise all those grievances on the domestic level. And when the prosecution and then the court, they see that it's like sort of, it's not only on domestic level you have some appeals from the lawyers, etc., but it's also it's raised on the upper level. For instance, if, as I have my personal experience, like in Czech Republic, the authorities they didn't allow me to visit my client in prison, in pretrial prison, and actually when I submitted a complaint before the first ombudsman office and then before the permanent representative of the Czech Republic before the European Court of Human Rights, afterwards immediately I get a positive response. So even because they ask me, in this way of so-called Italian strike, like, oh, you have to be admitted by the Czech bar, etc. But when they got a response from the Office of Permanent Representative, it was fine. Well, and it's like, as some speakers, it's always mentioned. It's always important about money. So, and it's like one of a key issue that any interference into property rights only be justified if it has legitimate public interest. It's based on the law, and it has to be of proportional nature. So, if, for instance, your property taken by state and you don't have any compensation, or the compensation given to you is completely insufficient to interference. So it means it's a violation. It's direct violation of article of your rights under the Article 1 of Protocol number 1. Thank you for your attention, and long live Liberland.